I'd rather lecture go. Well, it's very colourful today. The lecture go all right?
The one,
this morning's lecture.
Mine,
oh yeah.
Yes. I was doing the recent triple talaq decision. Yes. Good evening. Can we start, or are we still expecting people to walk in? I think we should start. We have an hour and a half today. So today also we will leave some time for questions, because both of us, actually three of us, were very happy with the kind of questions that we saw yesterday, and it was really very difficult to see who to give the prize to. I thought the questions with regard to the preamble, the question with regard to trickling down of interpretation, questions with regard to context were really very well taken for a first session that we had just opened up. So we were very happy with it. But I thought the question with regard to the Constituent Assembly debates was the most interesting, because it asked us to draw a parallel which we haven't referred to at all in our readings or in the outline. We haven't actually mentioned the process with regard to the drafting of the Irish Constitution, and so I thought that was the most interesting question. So, do you want to put your hands together for Harshita, who's clueless, by the way? Harshita, could you please come up?
All right, big chair, please.
So we look forward to more interesting questions today. I'm trying to make a very brief introduction to today's class. As you can see, we are moving from the introductory module into module 1, where the question, the most important question with regard to comparative constitutional law has always been the war between looking at constitutional texts as the most important source for interpretation, as against an understanding that you look at other sources for constitutional interpretation, even if, although we've put it up as if it is a binary between textualism and other and purpose of interpretation, but there can actually be other methods of interpretation. So, but the connect that I want all of you to make between what we were doing yesterday and what we're going to do today is to see how much of this debate around statutory interpretation has to do with comparative constitutional law as well. So if we are saying that expressivism, or the idea that every constitution, and this is something that we'll do tomorrow, and I'm asking you to make the connect to tomorrow as well, that if a constitution represents the identity of a country, and it is something that is found in the text of the constitution, then how can you interpret it in terms of the experience of another constitution? That's fundamentally the question. And if you have said that constitutions are a result of a certain political understanding and struggle around certain ideas, then how much of that understanding needs to influence the constitution rather than any other value that may or may not have been part of that struggle? So with this very small introduction, I now invite Justice MacMenanim to begin his lecture today.
Thank you very much. I want to be sure that you can all hear me up at the back. Can you hear me all right? Can you hear? Yeah? Okay. No, okay, good. Oh yes, I like that. Yeah, okay. I want to start today by making a confession. We're going to talk about a school of interpretation that I am not sympathetic with. But I also want to say that one of the effects of engaging in this course for myself has been that it has made me look at textualism and originalism much harder than I had thought likely before. And I'm going to talk very slowly, because it seems to me that the issues which we're facing are ones which actually do require a lot more thought than we normally do. Because I think that we tend to be, and I'm speaking for myself, I think we tend to fall victim to the prey of what's fashionable. And what conservatives say is that there has been effectively a conspiracy, not necessarily an organized conspiracy, but a consensus view established among liberal judges, among liberal media, among liberal commentators about what the law should be and whether laws should have a universal dimension. And the conservatives say, you're wrong about that. The law it is perfectly legitimate for the law to be confined to a particular country, because that's the job we have, interpreting the law of a particular country. And they also say that judges unthinkingly adopt a series of consensus viewpoints without engaging in any analysis. So if we look at the first slide, and I'm going to give you a series of quotations, and you might like to just write down one or two key words from these quotations. Just read it first. It's odd that one group whose members rarely discuss the intellectual framework within which they decide cases is the federal judiciary. Now, we're talking about America, which is effectively the home of originalism and textualism. And I'll tell you who the speaker was in a moment. And he goes on to say, judges by and large are not much attracted to theory. This is unfortunate, and perhaps it is changing. There are several reasons why it should change. And he goes on to describe judging as an intellectual system. Do you agree with that or not? He says it progressed through continual intellectual changes. And he says that judges should engage more in such discussion. And he then goes on to say we appear to be at a tipping point in the relationship of judicial power to democracy. And we have to draw a sharp line between judicial power and democratic authority. And he says that the future role of the American judiciary will be decided by the victory of one set of ideas or the other. And you might well feel that this is fairly dramatic, black and white stuff, fairly millennial. And the speaker there was a man called Robert Bork. And I'm going to tell you a little bit about him later on. Robert Bork was a candidate for the Supreme Court of the United States. His academic credentials were unimpeachable. The difficulty was that his views about the interpretation of the United States Constitution involved what is called originalism, that you looked either at the intention of the drafters of the Constitution, the framers, or alternatively the ratifiers, or perhaps contemporary opinion. Now, the net result of this was that, in effect, many of his decisions as an appeal court judge, this was before even he had become a candidate to go to the Supreme Court, were seen as ideology driven. And among Washington lawyers who appeared before him, there was a passive verb called to be borked, and that means that the judgment that was issued by the judge was intellectually very distinguished, but very, very ideology-driven. And his ideology tended to be originalist, looking back to the intention behind to the intention of the drafters. And the real issue that Bork raises is, if you engage in anything other than sticking to the text of the Constitution, what's your authority for this? What's your entitlement as a judge to engage in a broader or looser form of interpretation? And why I think this is important, and why Bork is important, not just in the United States, not just in Europe, but here as well, is because what happened on his hearing in the Senate, where he was questioned by the senators, was called and typified the beginning of the culture wars in the United States. The culture wars between the right and the left. And what happened to Bork was he was the subject of very considerable and very heavy criticism, some of it probably defamatory, as a result of which his nomination to the Supreme Court was defeated. And that gave rise to a verb, an active verb, called to Bork, which means to vilify or to defame to such an extent that somebody does not achieve or get a constitutional office. And what his principle was that his belief was that if you depart from the text of a constitution, that effectively what is happening is that you are being governed by the judge's own moral predilections, his own words. And if that is so, he said, where does this authority come from? Does it come from the Constitution itself? No, it does not come from the Constitution itself. It is subjectivism. It is creationism. It is a form of judicial interpretation which is illegitimate. And what Bork contended was that this was a form of illegitimate judicial exercise of authority, which ultimately, in his view, would undermine democracy. It's all those quotations that I've given that are being up on the screen summarize as much as I think we need to know conveniently about Bork's thinking. It's very, very easy, and I speak for myself, and I'm sure many people here, to dismiss all this as being antediluvian, backward-looking, non-progressive, absurd American conservatism. And yet, it's important to remember that we'll be looking at two judges, himself and Scalia, who you'll have heard of, who actually represented a very strong strand of American opinion, and you might say they were precursors to the election of Donald Trump. So, because they engaged in an interpretation of the Constitution about the right to bear arms, about crime, which represented something which was far, far different than the democratic consensus. Bork himself acted as Solicitor General for Richard Nixon. This will be a very long time ago, but he was involved in firing the special prosecutor who was appointed to investigate Watergate. He was appointed 30 years ago to the United States Supreme Court, and by the time of his nomination, he had exposed many of his ideas in writing. He was critical of, for example, the civil rights legislation in the United States, because he was critical of a judgment of the Supreme Court which struck down a state court decision banning contraception for married couples. He held there was no right to privacy under the Constitution, all of which, he said, was because there was no such right in the Constitution, and he said there is no right to depart from the Constitution. Unsurprisingly, perhaps, he also opposed any concepts of gender equality. Why he is relevant, and this is all background to the subject matter of our discussion, is he was one of the first academic judges, scholar judges, to object to the usage of foreign precedents in the United States. And he wrote a book, and I want to tell you what the title of the book is, because I think it says a lot. And the book's title is Coercing Virtue, Coercing, C-O-E-R-C-I-N-G, Virtue, the Worldwide Rule of Judges. So what he was contending for, in short, was that there was an agglomeration of judges all around the world who'd reached a consensus view in relation to what the state of the law should be, which was utterly at variance from what the United States Constitution provided for, and consequently, which raised big questions regarding legitimacy. So we go on. Why this is significant is the Bork hearings in 30 years ago now, in the opinion of many people, changed everything. And from then on, what happened is it legitimized, people say, the scorched earth policy which was adopted thereafter in United States Supreme Court hearings regarding the actual the beliefs of judges, with the result now that judges, when they're put up for elevation to the Supreme Court, engage in very non-committal answers indeed. So if we go on then to paragraph 16, to some of the questions that Judge Bork was asked by Senator Arlen Specter. And these are interesting because Arlen Specter was a Republican, he was a right-winger, but he took a different view from Bork about the interpretation of law. He quoted Bork in an article saying the text of the, we got the text of the Constitution, yeah. If you just read that for a second and take a moment, he said that the text enshrines profound values that necessarily admit the minor premises required to apply them. And the senator said, so from that statement, it seems to me a fair reading that it's pretty pretty hard to find. Is that my phone? Oh yeah, okay. If you just take my jacket and move it away. It's pretty hard to find the intent of the framers. And then he went on to quote articles that he'd written, where he raised the question about who is it you look to when you're interpreting the Constitution. Is it the judge's own view, or do you look back to the people who are enacting it? And the senator went on to say that there was an inconsistency between, on the one hand, looking at the people who had actually enacted the Constitution, that's the framers, and then saying after that, well, no, it should actually be the ratifiers, that is Congress. And he then went on to explore a number of other observations he'd made about legislation that Judge Bork disapproved of, paragraph 20, in relation to price discrimination. And it was in relation to a piece of legislation he called a pernicious act. And then the senator said, how do you enforce a pernicious act, Judge Bork? You have to enforce it. You may not like it, but you've got to enforce it. But how do you do it on the curved lines? In other words, when there's a difficult case. How do you do it on the complex factual issues which are presented to you, where as finder of fact you have the discretion to find facts? You could arguably find them in a variety of ways, so that an appellate court could not reverse you. Does it colour your thinking to find a set of facts A, so that you don't have to apply this pernicious law? And Bork, with commendable, perhaps intellectual honesty, said, well, Senator, I don't know, I've never been a trial judge. Not the best answer to give. And then he went on to talk about the act in question and said that it had been criticized by scholars from all different directions. And the senator said, I don't care, Judge Bork, the Congress passed it. And then he said, oh, I agree with that. But the difficulty that arises in the Bork doctrine of originalism was illustrated by another exchange, where the senator asked him about the War Powers Act. In other words, say the president has invoked his War Powers Act and that he has a fleet in the Persian Gulf, and the question is, who can declare war? Is it the President or Congress? If we don't have authority under the War Powers Act to require a certain presidential response, and then say no to the President, where does the Congress in 1987 exercise its congressional authority to declare war? Well, maybe you can do it under aspects of the War Powers Act. I see your point, Senator. It's a good point. I don't mean to dispute it. I thought it would be a little easier to tell the President, you've 2 weeks to get those ships out of there, and then there's no more money to be spent. Who's going to tell him? Well, I assume Congress would. If we just stop there and think about it in the exercise of presidential power, what this senator was saying is that Judge Bork wasn't living in the real world, and that if a president invokes the War Powers Act, Congress in reality would not be able to in any way put a check on the president. So let me say immediately that there are inconsistencies in the doctrine of originalism, because you could actually say, well, what was the convention, the United States Convention of 1789 to do? Well, it wasn't actually there to enact a constitution at all. It was actually to enact Articles of Confederation, a quite different thing. But we're coming on now to something which is very important. What did that convention do, and what did judges do with it? First of all, if you look at what the people in the convention did about in their vision of what judges should do, they knew that the Constitution would have to be amended in the light of events. And Benjamin Franklin said that the convention had to face the world as one body in either real or apparent unanimity. And you will go on to see that subsequently Madison, who was a member of the convention, who went on to be president, put away all his papers, you'll see the quotation there, so that they could not be put to improper account. They entrusted the papers to George Washington, and to make sure that what happened in the Constitutional Convention would not be cited, because they recognized circumstances changed. Now that's very different from Indian jurisprudence, where quite frequently you will see references to what people said in the Constituent Assembly. And if it comes to what my own philosophy is, I'd respectfully reflect what Ronald Dworkin says, that the kind of process we're involved in is one where you work layer by layer. You look at what the judges in the past have written, not only to see what they've said, but also to reach an opinion as to what they've done. And that he goes on, as you'll see in that quotation, to talk about the historical cooperative effort that judges engage in interpreting constitutions. And I would say that if I forced to define my own position, I would suppose I'm a civic Republican liberal, but I would say that that accurately describes the view of many judges, but not all judges, and in the Western world. I'm talking about the United States. But originalism has a number of problems. First, we just we just go on after we've looked at the Dworkin quote, and that's Dworkin looking distinguished, and after that we see what the problems with originalism are. First, it's a question of power. Who exercises judicial power? Who exercises legislative power? And the contention is that by over-interpreting the Constitution, or by engaging in a very broad interpretation of the Constitution, the judges are exercising illegitimate power because they weren't put there to interpret the Constitution in that way. And if we look at the next quotation, that raises the question of legitimacy, and then thereafter we can go on to look at the other issues which are there, that, for example, that if you want to amend the Constitution, the best way is by amendment. And then again, there's the other side, that the role of judges is to accept the fact that the law doesn't cater for every eventuality, that the role of judges is to fill in the gaps, and no written constitution can anticipate all the means, especially when a text is also often ambiguous, and that a different approach allows judges to head off any crisis that may happen. And it's also said that originalism is difficult because even at the very time of the adoption of the Constitution of the United States, the terms of the Constitution were intentionally broad. Now, this form of textualism is something which was very much part of the British common law. It's part of Indian law at the time of independence, and went on to be the format of interpretation by the Supreme Court of India up into the mid-60s, late 60s. For example, in the, and I want to reiterate the caveat that I gave you yesterday about I don't purport to be an expert in Indian law, but if you look at the Gopalan habeas corpus case, the question was, what was the power? What was the power to intern somebody in circumstances where the Indian Constitution used the word in accordance with used words which were in effect not a reflection of the substantive due process of the United States Constitution. And the real question is whether the word law included constitutional amendments. And the Supreme Court concluded that when they looked at the issue, the first issue was, did the words procedure established by law mean procedure validly enacted into primary legislation by Parliament, which would result in Article 21 being a safeguard only against executive action, or did it involve a substantive component? In other words, did it resembling substantive due process? And the court at that stage said no, textual analysis, and we take the view that if it's law, it's law. It had to face a second question, which was regarding the interpretation of Article 21 and Article 19 of the Constitution, whether they covered the same territory or separate territory, and they concluded that Kenya, Chief Justice appointed, adopted a black letter approach, looking at the plain meaning, and he said the expression procedure established by law must mean in its ordinary interpretation the procedure established by statute. And that was followed in a number of other judgments, which I don't think we need to go into, such as Singh being one example, again a textual analysis, and then also Golak Nath versus the state of Punjab. Now, all of this approach, if you want to see it very well summarized, it's in the Oxford Handbook of Constitutional Law of India, chapter 5, and it's called the Oxford Handbook on the Indian Constitution, page 79 onwards. This has a lot to do with comparative constitutionalism for a number of reasons. First, I think all of this discussion begs the question of what are we as judges doing when we're interpreting constitutions? To what extent are we entitled to adopt a broad interpretation rather than a more narrow interpretation? And we then come on to the great exponent of this, Antonin Scalia, who was appointed later to the Supreme Court of the United States, who criticized thinkers like Lawrence Tribe, Ronald Dworkin, who effectively, in his view, had illegitimized the judicial task. And he said that one should look at the text and only the text, and if it was ambiguous, you go to the legal tradition. And he justified the principle on the basis that it limited judicial discretion. The risk being that judges would insert their own predilections for what he considered to be an objective assessment of the law. And he said his view of this is there was a contract between the people of the United States and the judges that is embodied in the Constitution, and it is not susceptible to retrospective review. He effectively accused his colleagues of constitution making, and he, in a series of decisions after that, for example, Board of County Commissioners versus Waubonsee County, which are on remarkably boring subjects like the giving out of a garbage collection license, he actually expounded his philosophy. And he said, what secret knowledge? What secret knowledge, one must wonder, is breathed into lawyers. What had happened is his colleagues had adopted a much broader interpretation of the law than he had. And he said, what secret knowledge, one must wonder, is breathed into lawyers when they become justices of this court, that enables them to discern that a practice which the text of the Constitution does not clearly prescribe, and which our people have regarded as constitutional for 200 years, is in fact unconstitutional. So he was effectively putting it up to his colleagues to justify what their decision was, and to say, where did they get that authority from? And he says that the Constitution itself, or he said the Constitution itself defined rights and duties, and also engaged in the process of determining how rights and duties should be interpreted. So he, in a later judgment, he quoted and he gave an exposition of his philosophy. And we go to a quote in Rutan, paragraph 33, versus Republican Party of Illinois. And this leads on to what his view was in relation to the use of foreign jurisprudence and why it's particularly relevant to us. But first of all, if we look at what he said in Rutan, can everyone read that? Can everyone read that, by the way? Yeah? Okay. When a practice not expressly prohibited by the text of Bill of Rights bears the endorsement of a long tradition of open, widespread and unchallenged use that dates back to the Republic, we have no proper basis for striking it down. Such a venerable and respected tradition is not to be laid on the examining table and scrutinized for its conformity to some abstract principle of First Amendment adjudication devised by this court. To the contrary, such traditions are themselves the stuff out of which the court's principles are to be formed. These are uncertain areas, the very point of reference by which the legitimacy of or illegitimacy of other practices to be figured out. So he goes on to criticize the way in which the judges devised a three-part test, balancing test, a recalibration test, which in his view was an illegitimate exercise. Now, the difficulty is, of course, that if you're engaging in that process which purports to be an objective textual analysis, you can be criticized because you're looking to history, and the critics said Scalia did not fairly assess what history is about, and that he misquoted and that he was selective. And that while he said that he was looking fairly at his historical precedent, on the other hand, a judge called Richard Posner, who was quite an economic conservative himself on many issues, said that the doctrine of original meaning was illegitimate itself, because even when conducted in good faith, it's that judicial historiography rarely dispels ambiguity. Judges are not competent historians. Even real historiography is frequently indeterminate, as real historians acknowledge. To put to a judge a question he cannot answer is to evoke motivated thinking. Now, motivated thinking is you look for evidence to support what you want the answer to be. And motivated reasoning and motivated thinking is one of the great concerns that many people in the liberal world have now about looking for affirmatory material from the internet or from literature. Posner calls it the form of cognitive delusion that consists of credulously accepting the evidence that supports a preconception and of peremptorily rejecting the evidence that contradicts it. And if you ever get a moment and Google some of the disturbing surveys in relation to this conducted by Stanford University, you will see how very easy it is for people to accept material on the internet as being on the internet and look for stuff which confirms their own views, motivated reasoning, but reject anything that challenges their views. So what I want to do now is very briefly go through what Posner said. He said that he illegitimately cited authorities, that for example, he talked about the District of Columbia versus Heller. He said that he himself, that Scalia was engaging in an exercise of legislative history, and also that he engaged in an inconclusive historical analysis which was invalid. And he said, moreover, that Posner, who engaged in this criticism, it's on your reading list, talked about other exemplars of who are supposed to be textual originalism, but weren't really. They were rather loose constructionists. So if you look at Bobbitt's book, paragraph 37, Constitutional Interpretation, he analyzes a whole series of different forms of constitutional interpretation, including a number of labels or categories such as prudential, doctrinal, structural, ethical, which I would say can be conveniently used as a form of identifier. But I want to say, and this is where it's time to make confession, I think very few judges ever engage in that form of analysis when they're writing judgments. They engage in a rather more intuitive form of process, and we do not wake up in the morning saying, I'm feeling textualist today. You just don't do it. You don't wake up in the morning and say, hey, I'm feeling a bit liberal today. And there was a very good cartoon in the New Yorker many years ago with all the 9 Supreme Court justices of the United States, with one of them saying to the other, do you ever have one of those days where you feel everything is unconstitutional? And that, you know, judges don't do that. So why is this all relevant? Well, if we come on then to a judgment which was very, very interesting, which he talked about. This is a case called Roper versus Simmons. Now I'm going to do a little test with you about this case, because I'm going to tell you the facts about it. The appellant before the court was age 17. He lived in Missouri. With 2 other guys, he planned to do a robbery of a woman's house. He said, what we're going to do is we're going to rob the house and we're going to kill her. One of the intended perpetrators dropped out and said, no, I'm not going to do that. But he and another guy did. They robbed the house, they took this woman, they put her hands behind her back, they blindfolded her, they brought her to a bridge over a river and put her into the river where she died. He was age 17 at the time. The evidence was that he actually said to people before the crime, they can't hang us because we're 17, so we're safe. The evidence was that he had premeditation. So now we want to do a test, because as I understand it, correct me if I'm wrong, you still have the death penalty in India, yeah? Okay. How many people would say on those facts that he deserved to be hanged? No one at all. Anyone? No. Okay, that's interesting. As it happens, I completely agree with you. But I thought we might have one reactionary conservative among you. The reason why I put to you those questions was afterwards people looked at the trial and said he was utterly incompetently defended, that was psychiatric evidence which wasn't adduced, that he himself had been a victim of abuse from his father, and his father had effectively brutalized him. There was a question about whether he was psychiatrically ill. But what I want to do now is look at what happened, because, and this is where we're bringing it all back home to our situation in engaging in comparative constitutionalism. Could I have the mic there? Is that on? Okay. Yeah. Is this one? No. Is this one working? Yeah, thanks. What he did was if you look, what had happened in Roper is the majority in the Supreme Court cited a range of foreign precedents. They talked about the death penalty in England no longer being available at all. They talked about the abolition of the death penalty for minors in a range of other jurisdictions. They talked about the decision of the European Court of Human Rights. They talked about a worldwide consensus, a universal consensus in relation to the death penalty in relation to minors. But look what he said. What a mockery today's opinion makes of Hamilton's expectation, announcing the court's conclusion that the meaning of our Constitution has changed over the past 15 years. In other words, the court here was reversing a decision that had been made 15 years before. And if you look at the rest of the quotation, if we go on to the rest of the quotation now, if we could just go. And he said, and this is the critical bit perhaps, he said that evolving standards of decency of our national society are to be determined not by foreign authorities, but by United States opinion. He referred to the range of decisions which had been made in relation to death penalty by the various states. And effectively, if you read the quotation, which I think is available to you, and if you look at it, section 3 of the judgment, Roper versus Simmons, it is, to my mind, a devastating critique of the use of foreign authorities. Because what he does at the end is he says, well, okay, if the majority want to cite foreign authorities in relation to this issue, why don't they cite foreign authorities in relation to a range of other issues? Which they don't, because they don't suit. So what he effectively was saying was that his colleagues were engaging in a form of hypocrisy, or not hypocrisy, that's unfair, but double standards, quoting material that suited. The basic premise of the court's arguments is that America should conform to the laws of the rest of the world, ought to be rejected out of hand. In fact, the court itself does not believe it, in many significant respects, the laws of most other countries differ from our own. So the challenge for us, I'm talking about us collectively, is to look at the logic of that statement and say, well, what's wrong with the logic of that statement? If I ask myself, if we look at Indian jurisprudence, if we look at all the other jurisprudences in the world, Canada, Australia, where we all engage quite frequently in the citation of foreign authority, the issue, the question is, what's the legitimacy of that activity? And if we go back to Bork, we ask ourselves the question, well, is this some form of judicial universalism? Who elected the judges to engage in this kind of process? Who said the judges were elected at all? Who said that judges could get together in conferences and say, well, this is acceptable or this is not acceptable, we don't do this thing anymore? And what I think is significant from our point of view is it begs so many questions. Because I think the camera is now finished, so I can be a bit more frank. We're no longer recording, are we? Yeah, okay, good. Because I think that the challenge, you can put the camera away,